Important articles of the Constitution of the People's Republic of Bangladesh. Supremacy of the Constitution. Article 7. 1. All powers in the Republic belong to the people, and their exercise on behalf of the people shall be effected only under and by the authority of this Constitution. 2. This Constitution is, as the solemn expression of the will of the people, the supreme law of the Republic, and if any other law is inconsistent with this Constitution, that other law shall, to the extent of the inconsistency, be void. Fundamental principles of state policy. Fundamental principles. Article 8.1. The principles of nationalism, socialism, democracy, and secularism, together with the principles derived from those as set out in this part, shall constitute the fundamental principles of state policy. 2. The principles set out in this part shall be fundamental to the governance of Bangladesh, shall be applied by the state in the making of laws, shall be a guide to the interpretation of the Constitution and of the other laws of Bangladesh, and shall form the basis of the work of the state and of its citizens, but shall not be judicially enforceable. Equality of opportunity. Article 19.1. The state shall endeavor to ensure equality of opportunity to all citizens. 2. The state shall adopt effective measures to remove social and economic inequality between man and to ensure the equitable distribution of wealth among citizens and of opportunities in order to attain a uniform level of economic development throughout the Republic. Duties of citizens and of Republic servants. Article 21.1. It is the duty of every citizen to observe the Constitution and the laws, to maintain discipline, to perform public duties, and to protect public property. 2. Every person in the service of the Republic has a duty to strive at all times to serve the people. Separation of judiciary from the executive. Article 22. The state shall ensure the separation of the judiciary from the executive organs of the state. Laws inconsistent with fundamental rights to be void. Article 27. 1. Article 26.1. All existing law inconsistent with the provisions of this part shall, to the extent of such inconsistency, become void on the commencement of this Constitution. 2. The state shall not make any law inconsistent with any provisions of this part, and any law so made shall, to the extent of such inconsistency, be void. 3. Nothing in this article shall apply to any amendment of this Constitution made under Article 142. Equality before law. Article 27. All citizens are equal before law and are entitled to equal protection of law. Discrimination on grounds of religion, etc. Article 28. 1. The state shall not discriminate against any citizen on grounds of only of religion, race, caste, sex, or place of birth. 2. Women shall have the equal rights with men in all spheres of the state and of public life. 3. No citizen shall, on grounds only of religion, race, caste, sex, or place of birth, be subjected to any disability, liability, restriction, or condition with regard to access to any place of public entertainment or resort, or admission to any educational institution. 4. Nothing in this article shall prevent the state from making special provision in favor of women or children, or for the advancement of any backward section of citizens. Right to protection of law. Article 31. To enjoy the protection of law and to be treated in accordance with law and only in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Bangladesh, and in particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. Protection of right to life and personal liberty. Article 32. No person shall be deprived of life or personal liberty save in accordance with law. Safeguards as to arrest and detention. Article 33. 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, and nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, and excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and to such person shall be detained in custody beyond the said period without the authority of a magistrate. 3. Nothing in clause 1 and 2 shall apply to any person who for the time being is an enemy alien, or who is arrested or detained under any law providing for preventive detention. 4. No law providing for preventive detention shall authorize the detention of a person for a period exceeding 6 months unless an advisory body consisting of 3 persons, of whom 2 shall be persons who are or have been or are qualified to be appointed as judges of the Supreme Court, or the other shall be a person who is a senior officer in the service of the Republic, has, after affording him an opportunity of being heard in person, reported before the expiration of the said period of 6 months that there is, in its opinion, sufficient cause for such detention. 5. When any person detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicated to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making representation against the order, provided that the authority making any such order may refuse to disclose facts which such authority considers to be against the public interest to disclose. 6. Parliament may by law prescribe the procedure to be followed by any advisory board in an inquiry under clause 4. Protection in respect of trial and punishment. Article 35. 1. No person shall be convicted of any offence except for violation of a law in force at the commission of the act charged as an offence, nor be subjected to a penalty greater than or different from that which might have been inflicted under the law in force at the time of the commission of the offence. 2. No person shall be prosecuted and punished for the same offence more than once. 3. Every person accused of a criminal offence shall have the right to a speedy and public trial by an independent and impartial court or tribunal established by law. 4. No person accused of any offence shall be compelled to be a witness against himself. 5. No person shall be subjected to torture or to cruel, inhuman, or degrading punishment or treatment. Number 6. Nothing in this in clause 3 or clause 5 shall affect the operation of any existing law which prescribes any punishment or procedure for trial. Enforcement for fundamental rights. Article 44. 1. The right to move the High Court division in accordance with clause 1 of Article 102 for the enforcement of the rights conferred by this part is guaranteed. 2. Without prejudice to the power of the High Court Division under Article 102, Parliament may by law empower any other court within the local limits of its jurisdiction to exercise all or any of those powers. Establishment of Supreme Court. Article 94(1). There shall be a Supreme Court for Bangladesh to be known as the Supreme Court of Bangladesh, comprising the Appellate Division and the High Court Division. 2. The Supreme Court shall consist of the Chief Justice, to be known as the Chief Justice of Bangladesh, and such number of other judges as the President may deem it necessary to appoint to each division. 3. The Chief Justice and the judges appointed to the Appellate Division shall sit only in that division, and the other judges shall sit only in the High Court Division. 4. Subject to the provisions of this Constitution, the Chief Justice and the other judges shall be independent in the exercise of their judicial functions. Appointment of judges. Article 95(1). The Chief Justice and other judges shall be appointed by the President. 2. A person shall not be qualified for appointment as a judge unless he is a citizen of Bangladesh and has not for less than 10 years been an advocate of the Supreme Court, or has not less than 10 years held judicial office in the territory of Bangladesh, or has such other qualifications as may be prescribed by law for appointment as a judge of the Supreme Court. 3. In this article, Supreme Court includes a court which any time before the commencement of the Second Proclamation, 10th Amendment Order, 1977, exercised jurisdiction as a High Court or Supreme Court in the territory now forming part of Bangladesh. Jurisdiction of High Court Division. Article 101. The High Court Division shall have such original appellate and other jurisdiction and powers as are conferred on it by this Constitution or any other law. Powers of High Court Division to issue certain orders and directions, etc. Article 102(1). The High Court Division, on the application of any person aggrieved, may give such directions or orders to any person or authority, including any person performing any function in connection with the affair of the Republic, as may be appropriate for the enforcement of any of the fundamental rights conferred by Part 3 of this Constitution. 2. The High Court Division may, if satisfied that no other equally efficacious remedy is provided by law, on the application of any person aggrieved, make an order directing a person performing any functions in connection with the affairs of the Republic or of a local authority to refrain from doing that which he is not permitted by law to do, or to do that which is required by law to do, or declaring that any act done or proceeding taken by person performing functions in connection with the affairs of the Republic or of a local authority has been done or taken without lawful authority and is of no legal effect, or on the application of any person, make an order directing that a person in custody be brought before it so that it may satisfy itself that he has no he is not being held in custody without lawful authority or in an unlawful manner, or requiring a person holding or purporting to hold a public office to show under what authority that claims to hold that office. 3. Notwithstanding anything contained in the aforesaid foregoing clauses, the High Court Division shall have no power under this article to pass any interim or other order in relation to any law to which Article 47 applies. 4. Whereon an application made under Clause 1 or Subclause A or to Clause D, Clause 2, an interim order is prayed for, and such interim order is likely to have the effect of prejudicing or interfering with any measure designed to implement any development program or any development work, or being otherwise harmful to the public interest. The High Court Division all not make an interim order unless the Attorney General has been given reasonable notice of the application, and he or an advocate authorized by him in that behalf has been given an opportunity of being heard, and the High Court Division is satisfied that the interim order would not have the effect referred to in subclause 1 or subclause A or subclause B. 5. In this article, unless the context otherwise requires, person includes a statutory public authority and any court or tribunal other than a court or tribunal established under a law relating to the defense services of Bangladesh, or any disciplined force or a tribunal to which Article 117 applies. Jurisdiction of Appellate Division. Article 103. 1. The Appellate Division shall have jurisdiction to hear and determine appeals from judgments, decrees, orders, or sentences of High Court Division. 2. An appeal to the Appellate Division from a judgment, decree, order, or sentence of the High Court Division shall lie as of right where the High Court Division certifies that the case involves a substantial question of law as to the interpretation of this Constitution, or has sentenced a person to death or to imprisonment for life, or has imposed punishment on a person for contempt of that division, and in such other cases as may be provided for by Act of Parliament. Number 3. An appeal to the Appellate Division from a judgment, decree, order, or sentence of the High Court Division in a case to which Clause 2 does not apply shall lie only if the Appellate Division grants leave to appeal. 4. Parliament may by law declare that the provisions of this article shall apply in relation to any other law, court, or tribunal as they applied in relation to the High Court Division. Issue and execution of processes of Appellate Division. Article 104. Appellate Division shall have power to issue such directions, orders, decrees, or writs as a division may be necessary for doing complete justice in any cause or matter pending before it, including orders for the purpose of securing the attendance of any person or the discovery or production of any document, review of judgment or orders by Appellate Division. Article 105. The Appellate Division shall have power, subject to the provisions of any Act of Parliament and of any rules made by the Division, to review any judgment pronounced or order made by it. Binding effect of Supreme Court judgments. Article 111. The law declared by the Appellate Division shall be binding on the High Court Division, and the law declared by either division of the Supreme Court shall be binding on all courts subordinate to it. Establishment of subordinate courts. Article 114. There shall be, in addition to the Supreme Court, such courts subordinate thereto as may be established by law. Administrative tribunals. Article 117. Notwithstanding anything therein before contained, Parliament may by law establish 1. Administrative tribunals to exercise jurisdiction in respect or more of matters relating to or arising out of the terms of the terms and conditions of persons in the service of the Republic, including the matters provided for in Part 9, and the onward penalties and the award penalties or punishments. The acquisition, administration, management, and disposal of any property vested in or managed by the government by or under any law, including the operation and management of and service in any nationalized enterprise or statutory public authority. Any law to which Clause 3 of Article 102 applies. Number 2. Where any administrative tribunal is established under this article, no court shall entertain any proceedings or make any order in respect to any matter falling within the jurisdiction of such tribunal, provided that Parliament may by law provide for appeals from or the review of or decisions of any such tribunal. Thank you, viewers.